Everybody has a dog in reproductive freedom. Just because you don't have a uterus doesn't mean you don't have a stake in making sure that women's rights and bodies are protected. Because the logic that says women can't get abortions is the same logic that says you can't buy a condom. All right, chat, let's talk about the abortion stuff.
A seismic shift on abortion rights. As of this moment, Roe versus Wade essentially upended. At the stroke of midnight, the most restrictive abortion law in the country went into effect in Texas. It essentially bans all abortions after 6 weeks. 6 weeks before most women even know they are pregnant. Now, this law...
And it's in place. It's illegal. You cannot get an abortion in Texas now. The law's in place. It's being enforced. It's illegal. Welcome to what happens when the Republicans get 6 Supreme Court judges.
Private citizens the right to sue.
This is the thing that's wild. Listen to this. Listen to this.
6 weeks before most women even know they are pregnant. Now, this law gives private citizens the right to sue doctors or anyone else connected to a woman getting an abortion for as much as $10,000. All they need to do is help. It could be a Lyft driver to take a woman to a clinic who could be sued. In the timing on this is once a fetal heartbeat is detected.
So this law is in effect for now because the Supreme Court didn't act on a request to block it. Through their inaction, though, the justices have left the tightest abortion restriction since Roe versus Wade to be enforced, and the landmark decision itself could now be in jeopardy. So joining us to talk about all of this is CNN Chief Legal Analyst Jeffrey Toobin.
Good morning.
Why do you think the Supreme Court hasn't acted on this yet?
This is a very peculiar situation designed to create legal complications by Texas. Because of the law Berman just mentioned, the way the law is structured, it is not the state of Texas that enforces the law the way it works in most states, the way it works in every state. It is this system of private enforcement, private attorneys general, it's called. And
Brandon says the dumbest fucking comment I've ever seen. He made me use an F-bomb because it was so stupid. Okay, he's been following since today, so this is great. Don't like it, but that's none of my business. I don't watch mainstream media, only drinking bros, so I don't know what this is. Government has no dog in this fight. It's tyrannical. I'm not a woman, so I also have no dog in this fight. Brendan, bro. Everybody has a dog in reproductive freedom, bro. Everybody has a dog in reproductive freedom. Just because you don't have a uterus doesn't mean you don't have a stake in making sure that women's rights and bodies are protected. Because the logic that says women can't get abortions is the same logic that says you can't buy a condom, which was the state in America until Griswold v. Connecticut. Do you know what year that was? Do you know what Griswold v. Connecticut is? We've talked about it before. In 1965, in Connecticut, it was illegal for people to buy contraceptives. In 1879, Connecticut passed a law that banned the use of any drug, medical device, or other instrument in furthering contraception. A gynecologist at the Yale School of Medicine, C. Lee Buxton, opened a birth control clinic in New Haven in conjunction with Estelle Griswold, who was the head of Planned Parenthood in Connecticut. They were arrested and convicted of violating the law, and their convictions were affirmed by higher state courts. So it wasn't just abortions. Any drug, medical device, or other instrument in further contraception, and they were convicted. Does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraception? In a 7-2 decision by the Warren Court, these are people appointed by who, chat? Our big boy FDR, our big boy. That's why. A right to privacy could be inferred from several amendments in the bill, and Eisenhower, actually. Right to privacy can be inferred from several amendments in the Bill of Rights, and this right prevents states from making the use of contraception by married couples illegal. In a 7-2 decision authorized by Justice Douglas, the court ruled that the Constitution did in fact protect the right of marital privacy against state restrictions on contraception. While this court explained that the Constitution does not explicitly protect a general right to privacy, the various guarantees within the Bill of Rights create penumbras, or zones, that establish a right to privacy. Together, the First, Third, Fourth, and Ninth Amendments create the right to privacy in marital relations. The Connecticut statute conflicted with the exercise of this right and was therefore held null and void. Justice Black, joined by Justice Stewart, dissented. Unpersuaded by the loose reasoning of the majority, Black felt that there was no way to infer that the Constitution contained a right to privacy. He also dismissed the views of the concurrences that it would be found in the 9th and 14th Amendments. Justice Stewart, joined by Black, filed a separate dissenting opinion. Stewart argued that despite his personal view that the law was uncommonly silly, he felt that the court had no choice but to find it constitutional. And we don't have the Warren Court anymore, folks. So if you're a dude, and Griswold v. Connecticut is the basis by which Roe v. Wade is based on that right to privacy, which they found in Griswold v. Connecticut, because they literally prosecuted a gynecologist and the president of Planned Parenthood with a crime for counseling people about contraceptives, not abortion. Your rights are hanging by a thread. All right, let's get back. Let's get back to why abortion is being banned.
This difficulty is that it's created is that it's unclear who the abortion provider should sue. Usually you just sue the state government and the court issues an injunction on state government, don't enforce the law. With no single enforcer of the law, there is this procedural problem that abortion providers have, that it is unclear who they're supposed to sue.
Yeah, Dennis, thank you. I see that.
That's what's creating this legal tangle separate from
all right,
the
so
issue
we went down a rabbit hole, so I'm going to remind you what we were talking about.
The right to sue doctors or anyone else connected to a woman getting an abortion for as much as $10,000. All they need to do
say it again.
is help.
Say it again, chat.
At the stroke of midnight, the most restrictive abortion law in the country went into effect in Texas. It essentially bans all abortions after 6 weeks. 6 weeks before most women even know they are pregnant. Now, this law gives private citizens the right to sue doctors or anyone else connected to a woman getting an abortion for as much as $10,000. All they need to do is help. It could be a Lyft driver to take a woman to a clinic who could be sued. The timing on this is once a fetal heartbeat is detected.
So in other words, if you give a woman a ride to an abortion clinic and she gets an abortion, you could be sued by random people in Texas for $10,000. And say you are a volunteer for Planned Parenthood and you do it a lot, you could have multiple counts against you. They could bankrupt you.
The law is in effect for now because the Supreme Court didn't act on a request to block it. Through their inaction, though, the justices have left the tightest abortion restriction since Roe v. Wade to be enforced, and the landmark decision itself could now be in jeopardy. So joining us to talk about all of this is CNN Chief Legal Analyst Jeffrey Toobin.
Good morning.
Why do you think the Supreme Court hasn't acted on this yet?
This is a very peculiar situation designed to create legal complications by Texas. Because of the law Berman just mentioned, the way the law is structured, it is not the state of Texas that enforces the law the way it works in most states. The way it works in every state. It is this system of private enforcement, private attorneys general, it's called.
And of course, this will mostly affect low-income people as they won't have the means to go to other states and get an abortion. Yeah, we're going to talk about that.
This difficulty is that it's created. Clear who the abortion provider should sue. Usually you just sue the state government and the court issues an injunction on state government, don't enforce the law. With no single enforcer of the law, there is this procedural problem that abortion providers have, that it is unclear who they're supposed to sue. That's what's creating this legal tangle separate from the issue about the abortion law. But the effect is that this law is now in effect, and Roe v. Wade essentially does not exist, at least in the state of Texas, and probably more states to come.
There is so much about this that's fascinating, but it's that last sentence from you, Jeff, that I think people need to understand. As of now, Roe versus Wade, overturned isn't the right word, but upended, I think, is.
Exactly right. You know, January 23rd, 1973, the day of Roe v. Wade, was the last time a state had laws banning abortion. Today, September 1st, 2021, is the first day since 1973 where a state has legally banned abortion. There are no more abortion clinics functioning in Texas. Zero.
6 weeks. It's viability, fetal viability, which is about 6 weeks. And
there are 0 abortion clinics operating in the second largest state of the United States of America right now. Okay, I work in the civil legal field, and I just don't know how you can sue anybody without personal injury. I don't know how they will not overturn this law specifically of that fact, because Texas is creating its cause of action. Texas is creating a specific cause of action where the injury is assumed and the liquidated damages are set at $10,000. It's granting the standing via statute, which is something that it has the power to do. Now, there may be some complications about like totally unrelated things and like how many people can sue over the same abortion and all sorts of weird complications that may dog it technically and give courts the opportunity to throw it out. But right now, abortion clinics are not operating in Texas.
there are some estimates that about 85%, if not higher, of abortions in Texas take place after that. It's before most women even know they're pregnant.
Well, and remember, it's not, that's the law. But think about what an abortion provider has to think about in light of this law. If you are sued, not only sued successfully for aiding and abetting an abortion, that's the term that's used in the law. If you are sued successfully, you have to pay the $10,000 fine, you have to shut down, and you have to pay the attorney's fees of the plaintiff in the case, whoever the plaintiff may be. It could be somebody in Montana.
This is the more important part, because the attorney's fees are going to be well more than the $10,000. And now this is the actual way it works. This is a subsidy for conservative lawyers. Conservative lawyers just go find some guy to sue, and then they, if they could win these cases, could charge hundreds of thousands of dollars for legal fees, and then that goes on to the plaintiff. Or excuse me, on the defendant, the abortion provider, or the person that supported the abortion. It's not about the $10,000 is the headline, but the real number is the legal fees. And so you have this conservative lawyer industrial complex. Well, they'll be able to go around and bankrupt everybody who's a strong and public supporter of abortion in Texas. They are going to, not only do they disagree with you on abortion, not only are they going to try to ban it, they're going to try to ruin you if you engage in activism in favor of a woman's right to choose. We're entering the fascist stage of America, folks. Late stage fascism.
It could be the plaintiff. I mean, it could be anyone in the country suing to stop people from having abortions. So, being rational actors, these abortion clinics are saying, look, we're just not going to do this.
Yeah.
And that is the clear purpose of the law.
And obviously who it would predominantly affect are lower income women. And the Washington Post says 85 to 90% of people who get abortions in Texas are at least 6 weeks into pregnancy because they don't know that they're pregnant that early on. And the president of the Center for Reproductive Rights says now patients will have to travel out of state in the middle of a pandemic to receive constitutionally guaranteed health care.
This is exactly the same situation as if Roe v. Wade had been overturned. Because if Roe v. Wade is overturned, that means it will be up to each state. So, you know, virtually all the red states will ban abortion, but New York, California, many other blue states will not ban abortion. So the question will be, if you want an abortion in a red state, can you somehow make it to a blue state? Do you have the economic resources? Do you have the time? Or can you get what's called a medical abortion, which is an increasing way women are able to terminate their pregnancies through medication. But believe me, the red states are doing their best to ban that as well.
Again, and this is a roadmap for how they can do it, which is why I say, as of this moment, as we sit here at 7:05 Eastern Time today, Roe versus Wade has been upended in Texas, Jeffrey, and I'm curious because the Supreme Court did not step in overnight, and they could have. And as I said to Laura Jarrett before, doing nothing was doing something here. This is a statement. How am I supposed to read this from the Supreme Court overnight?
I think you are supposed to read it as doom is coming for Roe v. Wade. Now, entirely separate from this Texas case, there is a Mississippi case in the traditional manner of Supreme Court cases. You know, one of the, frankly, many outrageous things about what's gone on in Texas here is that the Supreme Court has acted in what's called the shadow docket. There was no briefing. There was no formal briefing of this case. There was no oral argument of this case. Roe v. Wade is sort of thrown out of the back of a caboose, you know, without any sort of ceremony here. Now, there will be a case about a Mississippi law that is almost as restrictive as Roe v. Wade, as this Texas law, that will be argued after October when the Supreme Court back. Now, that will be the opportunity for the 6 conservative justices, you just saw it on the screen, to formally end Roe v. Wade in the United States. But this decision has the effect of ending Roe v. Wade without actually performing the ceremony of burial.
While you're here with us,
Jack of Hearts, thank you for the tier 1 for 12 months. I see some people getting riled up. Of course, abortion care is health care. Of course, abortion care is medical care. But in the medical profession, there's a distinction between something that is called medical and something that is surgical, right? So a medical abortion is an abortion that is achieved through medication. And a surgical abortion, like D&E, is an abortion achieved through physically going into the womb and removing the embryo, removing the fetus.
This morning, I also want to get your opinion on
those are technical terms within medicine. It's not that surgical abortions are not medical care. They are. And I don't think that's what Tubin was saying. It's just these are technical, terms of art within the medical profession. When you say something's a medical abortion, you're referring to it being done chemically within the body as opposed to surgically, which is a physical intervention into the body.
House Minority Leader Kevin McCarthy said overnight, threatening essentially these telecommunications companies that have gotten requests from the committee investigating January 6th, saying essentially that if they comply, that they have hell to pay potentially if Republicans take the majority.
You know, one of the things you learn, Caitlin, as an assistant U.S. attorney, is that these telecommunications companies have entire offices devoted to responding to subpoenas. It is completely routine for Verizon and company to answer subpoenas. The idea that they somehow have the obligation, much less the legal right, to simply say to a valid subpoena, we're not complying, is incredible to me. Now, it is true, it is somewhat more unusual for a congressional committee to subpoena records than it is for an assistant U.S. attorney for the Department of Justice, but it still has happened before. So I really have no idea what legal basis Kevin McCarthy has to make this threat other than
fascism,
just bluster. Because
that's it.
Phone companies reply to subpoenas. That's what they
rule
do.
Of
Jeffrey,
law.
can you just go back to the Supreme Court for one second here? Because
so someone said something important. I am once again says, so this is a clear case, class, and race issue. In Texas, people can either afford to have kids or afford abortion tourism. Meanwhile, poor POC will be forced to have dangerous abortion procedures, pay massive fines, or have children. Then imagine the R's remove the child tax credit. No more support for these children people were forced to have. So just crushing low-income people further. You got it. It's about punishing women. It's about punishing people that don't live according to the way that they want you to live. It's about exercising power and control over women's sexualities. That's what a patriarchy looks like. That's what a right-wing hellscape is coming. And the only solution is revolution or packing the motherfucking Supreme Court, adding 4 more justices to the Supreme Court via passing legislation through the Democratic-controlled House, the Democratic-controlled Senate, signed by a Democratic president, who then goes ahead and appoints 4 new justices. Otherwise, it's over. and it's over for a generation.
This is something you've talked about and written about for a long time here. The Supreme Court in abortion has been very animating, perhaps more animating for conservatives, even though a majority of Americans supports abortion rights, certainly within the first trimester. What impact, if this sticks in Texas and this seismic shift happens, which as of right now it has happened, what impact do you think it might have politically? Could that animate Democratic voters?
You know, this has been the great unanswered questions. You know, Donald Trump ran for president saying, I will appoint justices to the Supreme Court who will vote to overturn Roe v. Wade. He has 3 appointees on the court. There are 3 other appointees on the court, Samuel Alito, Clarence Thomas.
Okay, actually, he didn't say he would appoint pro-life justices. He said that he believed women should be punished for having abortions. He didn't just want to overturn Roe v. Wade. He wanted to punish women for having abortions.
What should the law be on abortion?
Well, I have been pro-life.
I know. What should the law? I know your principle. That's a good value, but well, you know, what should be the law?
This presidential election is going to be very important because when you say what's the law, nobody knows what the law is going to be. It depends on who gets elected because somebody's going to appoint conservative judges and somebody's going to appoint liberal judges depending on who wins.
I've never understood the pro-life position. Well, I never understood it because I understand the principle. It's human life as people see it. But what crime? What crime is it?
Well, it's human life.
No. Should the woman be punished for having an abortion?
Look, I would say that it's a very serious problem, and it's a problem that we have to decide on. It's very hard.
But you're for
are you going to say, well, wait, are you going to say put them in jail? Is that
well,
the
no, what I'm asking you, because you say you want to ban it. What's that mean?
I am pro-life, yes.
What is ban? How do you ban abortion? How do you actually do it?
Well, you know, you'll go back to a position like they had where people will perhaps go to illegal places.
Yeah.
But you have to ban it.
Do you believe believe in punishment for abortion? Yes or no, as a principle?
The answer is that there has to be some form of punishment.
For the woman?
Yeah, there has to be some form.
10 cents, 10 years,
I don't know. That I don't know. That
why
I don't
not?
know. I don't know.
You take positions and everything else.
Frankly, I do take positions and everything else. It's a very complicated position.
I'm asking, you're running for president, I'm not. I'm asking you, what should a woman face if she chooses to have an abortion?
I'm not going to do that. I'm not going to play that game. You
said you're pro-life.
I am pro-life.
That means banning abortion.
And so is the Catholic Church pro-life.
And Texas has said, what's one of the ways you're going to punish the women? Bankrupt them. They have to pay $10,000 and all the legal fees of anyone who helps them or get that abortion. Bankrupt every single person who's involved in in helping women get abortions. That's one of the punishments. That's just the beginning, folks.
And John Roberts, who have spoken out against Roe v. Wade before, although Roberts has later said he supports the precedent. But there are 5 justices, it appears, the 3 Trump appointees, plus, there they are on the screen, plus Thomas and Alito, who seem like solid votes to overturn Roe v. Wade. You know, we've been accused, those of us who have been saying that Roe is about to be overturned, as being Chicken Little, the sky is falling, the sky is falling. We'll see, because it certainly looks like the sky is falling now. You know, Republicans have been very upfront about what they want to do on the Supreme Court, but they haven't done it yet. As of now, as of the Mississippi case, they may actually do it, and we'll see what, if any, political blowback there is. You know, it has certainly been a more animating and successful issue for Republicans than for Democrats, but as states start to outright ban abortion, maybe that'll change. But I don't hazard a prediction about that.
Jeffrey Toobin, thanks so much.
All righty, pal.
Not a joke, chat. Not a joke, chat. So this is the Center for Reproductive Rights. And a couple years ago, they put together what if Roe fell? The worst case scenario of what would happen if Roe v. Wade gets overturned and what it would look like in various states. So they made a map, and one thing you'll notice is that a lot of places, especially purple states, abortion rights are either not protected or outright already illegal. And they're waiting for the overturning of Roe v. Wade for what are known as trigger laws, or all these excessive restrictions that were overturned by the Supreme Court but still remain on the books, just unenforceable. Well, if Roe v. Wade goes away, if Planned Parenthood versus Casey goes away, then all those previously unenforceable laws become enforceable. They are what's known as a trigger law. The Supreme Court passed Roe v. Wade nearly 50 years ago, making abortion legal across the United States, but the court's makeup has shifted in recent years. 5 states currently have what is known as trigger laws in place. They express a legislative intent to ban all or most abortions as soon as it's legally and constitutionally possible to do so. While a majority of these laws were passed more than 10 years ago, Ziegler said she believes these type of measures are now gaining popularity and could have a higher chance of successfully navigating through state legislatures. Similar legislation is currently being considered in several states, including Tennessee and Kentucky. In Arkansas, the state's trigger law went into effect last month. All abortions will be banned except in the case of medical emergencies. Louisiana, former Democratic Governor Kathleen Blanco signed an act to ban abortions in 2006. The only exception is when a mother's life is in danger. Under the state's rule, abortions would become illegal 10 days after a SCOTUS decision. The exceptions would include a pending rape prosecution or if the mother's life is in jeopardy. North Dakota passed legislation in 2007. An abortion would only be defensible in court if it were deemed necessary to prevent the death of the mother or the pregnancy resulted from rape, sexual abuse, or incest. In South Dakota, all abortions would be deemed illegal except those deemed medically necessary by a doctor. So, for example, in Florida, in Georgia, for example, Georgia would likely try to prohibit abortion by enforcing its 6-week ban on abortion. The law, enacted in 2019 and permanently enjoined, is intended to prohibit abortion before many people know they are pregnant. Numerous medically unnecessary restrictions already make it difficult to access abortion care in Georgia. What state do you want to look at, chat? What state do you want to see? Illinois? Okay. Abortion will remain legal in Illinois. In 2019, Illinois enacted comprehensive abortion rights legislation, and the Illinois Supreme Court has recognized the right to an abortion under a state's constitution. Now, yellow means protected, blue means expanded access, this like light red is not protected, and red means hostile. Tennessee? All right. Tennessee will likely try to prohibit abortion. In 2019, Tennessee enacted a trigger ban intended to make abortion illegal in almost all situations if it ever became legally permissible. Currently, medically unnecessary restrictions make it difficult for people to access abortion care in Tennessee. So Tennessee apparently has a trigger ban. This other article was from 2019, so this was enacted apparently after this article because Tennessee was not listed. What else do we got? Wisconsin? Wisconsin lawmakers may try to prohibit abortion. The current governor is supportive of abortion rights, but state law does not expressly prohibit abortion. Numerous medically unnecessary restrictions already make it difficult for people to access abortion care in the state. So you have a Democratic governor and a gerrymandered Republican legislature. In Wisconsin, they have the most gerrymandered state legislature. In fact, the Republicans lost the popular vote by 10 points, and they controlled the state legislature anyway. New election data shows the ongoing impact of the 2011 GOP redistricting in Wisconsin. Detailed election data posted by the state this week illustrates once more the ongoing impact of Wisconsin gerrymandered Republican-friendly legislative map. Governor Scott Walker lost his bid for re-election by roughly 1 percentage point November 6th to Democrat Tony Evers. Yet Walker carried 66 of the state's 99 state assembly districts. In fact, data shows that 64 of the 99 districts are more Republican than the state as a whole based on their vote for governor. In other words, Republicans enjoy a built-in 64-35 advantage in the partisan makeup of 99 assembly districts. In a hypothetical 50-50 election in which there are equal numbers of Democrats and Republican voters in Wisconsin, no one crosses party lines and independents split down the middle, that translates into a massive 29-seat GOP advantage in the assembly. That's very close to the 27-seat margin that the Republicans won last month. Republicans enjoy a natural edge in the battle for the legislature because Democratic voters are more concentrated geographically in urban areas, especially Milwaukee and Madison, meaning their voting power is confined to a smaller number of districts. The legislative map by the GOP in 2011 added greatly to the natural Republican advantage. Under the old map, Democrats had to outperform the GOP by 2 or 3 points statewide to have a good shot of winning control of the assembly. But under the current map, Democrats need to outperform the GOP by closer to 9 to 10 points statewide to have a good shot at winning an assembly majority. Aside from locking in Republican control, the gerrymandered map has also killed off competitive assembly elections. To maximize their partisan advantage, Republicans drew a minority of hugely lopsided Democratic districts, minimizing the impact of the Democratic vote, and a sizable majority of less lopsided but safe GOP seats. That leaves hardly any truly purple assembly districts in the purple state. In November 6th election, only 5 of 99 assembly races were decided by less than 5 points. Only 2 were decided by less than 3. So in other words, we can't win the elections because they're all rigged. By the way, in the Senate right now, the Democratic House already passed H.R. 1, the For the People Act, which banned partisan gerrymandering in congressional districts and mandated that states draw their districts with a nonpartisan redistricting commission. And Joe Manchin and Kristen Sinema are not bringing it up because they don't want to do anything without Republican votes. Republicans are literally planning to gerrymander and rig our elections for the next decade, and the Democrats have a law that makes it illegal, and it's sitting there in the Senate that the Democrats control, rotting. So even if your state would vote for abortion rights, you can't because they're rigging the elections. So you've got to tell the Democrats to get off their ass and prevent this from happening for another decade, because it already happened. Can we slip H.R. 1 into reconciliation and not tell Manchin and Sinema? They'll know. Don't worry. They'll know. They'll know. What happens if the fetus has severe medical issues like a mental issue or rare diseases that would make it disabled? Is the woman still forced to give to birth it now? Yes. Yes. In fact, the Republicans are trying to ban what they call abortion eugenics, where you would get criminally charged if you got an abortion for a fetus that had genetic abnormalities. They're trying to make that a crime. PA House Republicans advance ban on abortions over Down syndrome diagnoses. Republicans in the Pennsylvania House pushed through a bill Tuesday that would ban abortions that are prompted by a prenatal Down syndrome diagnosis, although the Democratic governor has vowed to veto it. I believe we truly have a responsibility to stand up for those who do not have a voice, Klunk said. If it becomes law, the proposal will require a doctor who performs an abortion to provide a written statement that it was not motivated in any way by a prenatal diagnosis or test indicating Down syndrome. This legislation could prevent patients from seeking the information they need to become the best parents possible when they need it the most, said Rep. Dan Frankel of Allegheny, who voted against it. He said the bill makes it a crime to think and consider options. Rep. Kathy Rapp compared abortion over a Down syndrome diagnosis to genocide. People with Down syndrome are living longer than ever, and they're happier than most of us, Rapp said. Why are many of them being aborted, and why? It's a curious and heart-wrenching question because there has never been a better time in all of history for people with Down syndrome. The bill would make it a third-degree felony for the doctor who could lose his or her medical license. There is no criminal penalty for the expectant mother. I would actually put doctors in jail for performing this procedure, said Rep. Leanne Kruger. It would actually put doctors in jail. Sorry, Leanne, I misspoke. She noted the bill has no exceptions for pregnancies that resulted from rape or incest or when a mother's life is at risk. Politicians should not make this decision for us, Kruger argued. It was sent to the Republican majority state Senate for consideration. Governor Tom Wolf, a Democrat, vetoed similar legislation in 2019 and recently reiterated his intention to veto the new version. But remember, chat, the Republican state legislature is gerrymandered just like Wisconsin. If I had known about the genetic issues in my husband's family, I would never have had kids. I didn't give a kid a 50-50 chance of living in pain their whole life. I mean, listen, I'm not here to tell people what is a good reason to get an abortion. As far as I'm concerned, you can get an abortion for any reason. It's your body. You have the right to control whether or not you want to bring a fetus to term. That's your decision. It's not my job to second guess what you're thinking about your own body. I don't get to tell you that you are an incubator against your will. Your reason or no reason whatsoever is totally valid, and I'm not here to judge you or get inside your head. That's absurd, and that is authoritarian in a psycho way. People get abortions because they need them, not because they want them. Exactly. So what other states do you want me to look into? Oklahoma? Oklahoma will likely try to limit or prohibit abortion. In 2021, Oklahoma enacted a trigger ban intended to prohibit abortion in almost all situations if ever legally permissible. Numerous medically unnecessary restrictions already make it difficult to access abortion in the state. Here's Oklahoma. They have a, by the way, chat, this website, if you go to it, it's reproductiverights.org. What if Roe fell? If you click on a state, for example, let's say Indiana, it has this pop-up and it gives you a PDF and it'll tell you a little bit more about your state in particular. For example, Indiana, hostile. If Roe is weakened or overturned, Indiana law prohibits abortion at the earlier of viability or 20 weeks post-fertilization. It also prohibits DNX and D&E procedures. An abortion sought for reasons of sex, disability, race, color, national origin, or ancestry of the fetus, though the reason bans are enjoined. Pregnant people who seek abortion care must undergo biased counseling, an 18-hour mandatory waiting period, and an ultrasound. Indiana also limits public funding for or private coverage of abortion. Indiana law generally requires that a parent or legal guardian or judge consent to a minor's abortion. Indiana's targeted regulation of abortion provider law include requirements related to facilities, admitting privileges, and reporting. Indiana law restricts the provision of abortion care to licensed physicians and restricts providers from using telemedicine in the provision of abortion care. Providers who violate Indiana's abortion restrictions may face civil and criminal penalties. Indiana law does not include express constitution or statutory protection for abortion. To the contrary, Indiana statutes include language indicating its policy preference to ban abortion to the fullest extent of the law, including that childbirth is preferred, encouraged, and supported over abortion. If Roe v. Wade is limited or overturned, it is likely that Indiana will try to prohibit abortion entirely. And here's the citations to the different statutes if you want to know more. And it's not just red states, chat. It's a lot of purple states. Look at this dog shit take and why Bernie is trending on Twitter right now. Okay, hold on. I'm rather resentful toward the Jill Stein, Gary Johnson, and Bernie or bust folks with their protest votes because even Trump would be better than Hillary. I don't trust her crap. And you know what? These smug assholes never even admit they were wrong. Hashtag Roe v. Wade. I mean, listen. I gotta be honest with you, chat. I told people to vote for Hillary 2016, but the reality is we told you so. We told you she was unpopular. We told you she was a bad choice. You said she was a safe choice. We said I voted for her because of the Supreme Court. But I told you, don't pick her. Don't nominate her because she's going to lose. And you guys put your thumb on the scale and selected her. And she did her best to put Trump in office and get him out of the Republican primary. They called it the Pied Piper strategy. Pick the worst candidate. And he won. We were right. You were wrong. Don't try to point your fingers at randoms. You said she was the safe choice and she wasn't. So just so it happens, the anti-abortion bullshit fits like a glove with the white grievance policy. The whole deal about white genocide. Gotta force those white women to have those white babies. You got it. More people voted Green Party in 2016 than defected from Bernie to vote for Trump. Yet, where's all the contempt and scorn for Green? I mean, listen, voting for Green Party or writing in Bernie Sanders in 2016 was the wrong move. I'm sorry. Hillary would have been, just the Supreme Court alone was worth voting for Hillary. And now we're seeing the result. But guess what? We have the power to fix it now. Here, I'm gonna make a tweet. I'm going to make a tweet, chat, just because I'm getting tilted by the stupidity. All right, chat. What do you think about this tweet? If you're mad, stop being mad at Bernie or Busters in 2016 or Green Party voters. Tell the Democratic Party to pack the Supreme Court. They have the power to do it. All they have to do is pass a law. In the Constitution, the size of the Supreme Court is set by law. So all you have to do is change the law. The Supreme Court has had its size changed. It's grown and shrank over the years many, many times. You mad about the Supreme Court? Pack the court. The closest legal abortion for a Texas woman more than 6 weeks pregnant living in the Valley is now a 9 hour and 26-minute drive away. Holy shit, man. They could pass legislation making abortion legal rather than relying on a court. Yeah, that too. If Roe v. Wade gets overturned, how long do you think it will be until cons ban abortion terrorism? Well, that would be pretty difficult to legally do, but at the federal level, I guess it's possible. They could ban abortion at the federal level, possibly. Will Republicans pack the court in their favor even more when they regain power in the midterms? You need to have the president to do that. The way it works in America to pass a law is that a law has to be passed through the United States House, United States Senate, and then it goes to the president, and the president has to sign the law. Or if 2/3 of the House and Senate vote, they can override the veto of a president and pass it into law anyway. But for the Supreme Court to increase in size, the Republicans would have to control the White House, the White House, the House, and the Senate in order to increase the Supreme Court. So, for example, if the Dems now expand the Supreme Court, appoint 4 judges, and then they lose the House and the Senate in the midterms, because Biden is still the president, the Republicans couldn't counterpack. By the way, there's nothing stopping the Republicans from packing the Supreme Court the next time they control anything anyway. They will have the power to do it because it's a power that they have to do. So if the Republicans decided they wanted to pack the Supreme Court, they could pack it no matter what the Democrats do. So that's really not an argument. And then the Supreme Court has to allow the law to stand. There's no way for the Supreme Court not to allow the law to stand because it's a direct power in the Constitution saying that the Congress shall make a law establishing the Supreme Court. So the Congress can change the number of judges at whim, assuming assuming as it gets like any other law signed into law. They could add 100 judges to the Supreme Court. In fact, FDR wanted to add a judge for every judge over 70. What was this court packing scheme? The bill name is Roosevelt's court packing plan. Roosevelt won a sweeping re-election victory. In the months following, he proposed to reorganize the federal judiciary by adding a new justice each time a justice reached age 70 and failed to retire. Yeah, there you go. He wanted to add a judge for every time they hit 70. I also think it's worth packing the Supreme Court to start the conversation among the wider public about how the efficacy of life-appointed justices. I hope Republicans talk about how arbitrary the number of justices are to get people to realize how draconian that whole branch is. Hopefully it'll get people to think about reforming the judiciary, like adding term limits for judges, etc. Would they ever win without gerrymandering? Sometimes. But they are the minority party. Just keep adding judges that are already over 70. Infinite judges hack? Yeah, true.